Welcome back to Believers IAS Academy. In this today's particular video, we will be discussing about the Chief Election Commissioner. Now, if you're wondering as to why Chief Election Commissioner, as a topic, is because of what is currently going on, and what is going on for that matter. It is the removal that the India bloc, the opposition, is demanding to move the motion against the Chief Election Commissioner, Gyanesh Kumar, in order to remove him from the office and from the post of Chief Election Commissioner. Now, why this is happening, or if you have been through or followed the newspaper, the current affairs from like last couple of months, it is in news with respect to the Bihar election, where a whooping 65 lakh voter list were absolutely removed as a part of special intensive revision, the SIR. And after the very recent verdict by the Supreme Court, an interim order of the Supreme Court, which it asked the election commissioner to disclose the voters list, the electoral roll of all the 65 lakh voters which was removed. And the issue concerning this particular part, and the very recent press conference held by the Chief Election Commissioner, where the way he responded to the questions asked by the India bloc, the opposition, is pretty much in news. Of course, that is not important as part of the examination, but what is important is the office of Chief Election Commissioner, which is part of your Indian polity, and we study this as a part of your prelims, and also becomes very important for the mains examination also. So what is in news is obviously not required in terms of the particular topic as to what are the dynamics that are happening, but in general you need to understand the causes as to the issue of this particular news, which is one that it goes completely, or it goes to the heart of electoral integrity of the nation, directly affecting the democracy, which obviously makes it important for us to know as to how this is affecting the democracy and the electoral integrity of a country. And also this becomes important because the opposition wants to frame it as a fight against the scene, or the fight against the things that are happening, which are taking democracy to a different level, right? Of course, opposition, as we know, they don't have enough numbers in order to move the motion, because how does a Chief Election Commissioner gets removed? It's pretty much the same as to how a Supreme Court judge, or how the Chief Justice of India gets removed through a special majority. Of course, opposition right now do not hold that majority or the numbers in the Lok Sabha to remove the Chief Election Commissioner, but still it is in news. It is because of the opposition's verdict, or the say that this stands, which states that even if we don't have numbers, right, to remove the Chief Election Commissioner, but this, they wanted to frame it as a fight against or fight for fair elections of the country, which highlights the growing tensions between the election commission and the opposition, right? So now the point to remember here is how this particular issue is affecting the electoral integrity of the country, and also affecting the democracy of the country. Because if we see the relevance of this particular topic, UPSC has been asking questions related to Chief Election Commissioner, and most prominently in their main stage, we can see in the year 2022 there was a question which goes discuss the role of Election Commission of India in the light of the evolution of Model Code of Conduct. Of course, from the same topic, and this was from the previous year mains paper of the GS2, which directly talks about the need for electoral reforms as suggested by various committees, with particular reference to one nation, one election principle. So of course you can understand, or it is very evident as to how important this particular topic is with respect to the UPSC preparation, and most importantly the mains examination, which makes it absolutely necessary for you to understand, or remember, or to make efforts to know as how it is affecting the electoral integrity and the democracy of the country. So even before we get into that particular aspect, we will first try and understand what the election commission, or what is the role of the chief election commissioner is, and what are the key provisions of the particular act that talks about chief election commissioner, his appointment, tenure, and all of it in detail, right? So speaking of which, the very first thing that we have to keep in mind is the recent 2023 act, which was enacted in order to replace the age old, the previous act, which is the Election Commission Conditions for Service of Election Commissioners and Transaction of Business Act, or simply the Election Commission Act 1991, right? So this was replaced by the recent 2023 act. Even this is also in news. This is also is pretty much controversial in nature, because the present chief election commissioner, Mr. Gyanesh Kumar, was also appointed based on the 2023 act itself. But even that is also controversial as to why, or the process in which he was elected, the select committee which was formed in order to elect Gyanesh Kumar. Everything was in news right from his election tenure, as in right when he was appointed. So now it becomes absolutely important for us to know what this chief election commission is, or for that matter the particular 2023 act is. So as we first discussed, it replaced the Election Commission Act 1991, and this particular act, the Amendment Act, governs what? It governs the appointment, tenure, service conditions of the chief election commissioners, and also the election commissioners of the states as well as the procedures of the election commission, as to how the election commission functions, or anything related to the office of election commission is what is considered to be important, or what constitutes all of that is talked under the 2023 act. So now let's understand the judicial background of this particular act also, because it is very important that, talking of the controversy behind this particular act, it is important to know the judicial background also, because it was enacted after the Supreme Court scrutiny of the center's exclusive control over the appointment. So what it clearly states is that the earlier stands were such that the center's exclusive control were present in the appointment process of the entire chief election commissioner. So it categorically had a few provisions, or the select committee, according to which it constituted the prime minister, leader of opposition, and also one minister, one cabinet minister who is appointed by the prime minister, is what was talked about in the previous act, which of course in the Anoop Baranwal case 2023, the Supreme Court ruled that until Parliament frames a law to change this particular provision of the select committee, appointment should be made by a panel of members consisting the prime minister, the leader of opposition, and in place of the minister appointed by the prime minister, it talked about having the Chief Justice of India in place of the one minister, the cabinet minister, who is appointed by the prime minister. Now this was to ensure that the role of the majority party, right, or the dominance of the majority party is not seen in the select committee of the chief election commissioner, who further undertakes or controls the entire election system in India, right, in order to prevent the bias, right? So that was the Supreme Court's judgment, and this case becomes absolutely important to keep in mind, even for prelims, and also it will be a very good value addition for your mains answer writing as well, which is the Anoop Baranwal case, where the Supreme Court ruled that until the Parliament framed the law, the appointments should be made by a select committee, which also has the Chief Justice of India, right? So before this judgment, the chief election commissioner and the election commissioners were actually appointed by the president, but how? On the advice of the Union Council of Ministers headed by the prime minister, which obviously was very much biased towards the majority party, as in they could have selected, or they could have elected a person whom they preferred would take care of the entire election process of the country. So now this would definitely not ensure free and fair elections as per the constitutional ideas, or as per the ideal of the constitution. So hence this judicial background, in order to understand that, is also very important. Now let's move on to the key provisions of the 2023 Act. So first it talks about the selection committee, as to who forms, or who are all those people who constitute the part of the selection committee. So it clearly states that the president appoints the person based on the recommendations given by the committee, consisting of three important personalities. One is the Prime Minister, who is the chairperson of the select committee, then the leader of opposition, or the leader of a largest opposition party in the Lok Sabha especially. And it talks about what? A union cabinet minister nominated by the Prime Minister. So this was the very first provision of the 2023 Act, and of course this is how the present Chief Election Commissioner is also appointed, right? So of course, talking about the drawback, this is also one of the huge drawback and one of the setbacks, that the clear separation of power is not observed, because although Supreme Court gave a verdict stating that this goes against the free and fair election that it is supposed to observe, but still it completely, the Parliament or the Cabinet completely ignored the Supreme Court's advice to add Chief Justice of India in the Select Committee. So this is also one biggest drawback, or one of the biggest controversy that is there in news ever since Mr. Gyanesh Kumar was appointed as the Chief Election Commissioner. Well, coming back to the provisions, so this is the first provision with respect to the Select Committee, very important. And moving on, it also talks about having a search committee, because Select Committee is the panel of members who select the particular person, but there is a search committee before the Select Committee who has to collect all those people, right? Collect all the Chief Election Commissioners, the nominees, or let's say the candidates. So this particular committee is headed by the Law Minister himself, with two senior officials, of course, not below the rank of secretary. So it mandates a very clear hierarchy in terms of who becomes the persons, the panel members of the search committee, and it talks about the Law Minister himself and two senior officials, of course, not less than the secretary rank, and they are the ones who prepare a panel of 5 candidates, and there is no hard and fast rule that only 5 candidates are supposed to be selected, because under the section 8, right, the select committee can also consider more number of candidates also, right? Then talking about the eligibility criteria, the Act talks about the eligibility of the person who who heads the Chief Election Commissioner, commissioner. So it must have held, let's say the person must have held the post of secretary to the Government of India or any equivalent post. So here I'm mostly talking about civil servants who are mostly IAS officers, right, at the level of secretary, at any particular ministry, at the Government of India level or any equivalent post. So usually it is the IAS officers who goes on to become the Chief Election Commissioner. So the eligibility criteria clearly mandates that. And also it talks about another important thing, where it talks about the person possessing or showing the qualities of integrity and relevant experience in election management as well, right? So this is the third particular provision. Now moving on to the other one, it also talks about the salary, tenure and reappointment nature of the Chief Election Commissioner or the election commissioners. So salary, it is equivalent to the Supreme Court judge, you have to keep in mind. And talking about the terms, it is 6 years or until the age of 65 as the maximum, whichever is earlier. And talking about the reappointment, it is very clear very important to keep in mind that no reappointments are possible, and it is not allowed. That as in, if an election commissioner becomes a Chief Election Commissioner, the combined tenure cannot also exceed 6 years. This is also important to keep in mind. Reappointment is also not available, and the pension adjustment, with respect to the person, who is elected as the Chief Election Commissioner, if he is receiving a government pension except disability pension, the salary is reduced accordingly. So of course all these minute details are not required. Only important thing to keep in mind is with respect to his reappointment, and also with respect to his terms and tenure, and also with respect to the salary that is being given to him, right? Now, talking about the removal and the resignation, this is a very important point, because the right now news in which is on the platter talks about the removal of the chief election commissioner, and according to the act, it says the chief election can be removed only like a Supreme Court judge, right, via parliamentary motion, and can be removed on the recommendation of the now talking about the chief other election commissioners apart from the chief election commissioner, they can be removed on the recommendations of the chief election commissioner, but both may resign to the president, which means the chief election commissioner, if he has to be removed, right, he has to be removed or he can be removed pretty much like a Supreme Court judge. And talking about the removal process, it is the special majority, right, the special majority in the parliament with a minimum of 50 signs, 50 people voting for the motion, right, saying that we want the removal to be happening. And also it talks about how the election commissioners are removed. It's basically the recommendation, based on the recommendation of the chief election commissioner, they can be removed, and both the chief election commissioner and the election commissioner can themselves resign by writing it to whom? The president. So this is also very, very important. So now that we have understood the 2023 Act, let's also understand the challenges with respect to the key issues, the challenges with respect to this particular Act. So first and foremost is the exclusion of the Chief Justice of India. As we have earlier discussed, the earlier Supreme Court mandate was to have a panel which also includes the Chief Justice of India in place of the cabinet minister, right? So this was to ensure that the balance is in favor or is not in favor of the executive, reducing the judicial oversight, right? Because now amongst the number of persons who are present in the select committee to select the chief election commissioner, we have the prime minister, we have the leader of opposition, and also we had according to the present according to the act, it talks about having a cabinet minister. So now when you see 2 out of 3 votes, right, will obviously be from the majority party, because the prime minister is from the majority party. Even the cabinet minister is someone whom he appoints, obviously from the majority party. And this is just Namka Vasta role, the leader of opposition, who is just there for the namesake, right? Even though he doesn't want the person to be obviously elected as the chief election commissioner, it is impossible, because already the prime minister and the cabinet minister, who is part of the majority party, and also the panel of members, whoever selects from the search committee, will definitely have an inclination to select that person who would be favorable to the majority party, right, favorable to the prime minister or the cabinet. So ultimately the issue is that there is no proper balance. So the Supreme Court judge verdict clearly states that in place of this cabinet, right, the Chief Justice of India should be there in order to balance the entire situation, where the judicial oversight can take place in terms of electing or selecting or appointing that particular person, which is not there. One of the huge drawback with respect to the appointment of the election commissioner, the chief election commissioner. Second important thing is the separation of powers in question, right? Because we have clear demarcation, separation of powers with respect to your judiciary, your executive, and the legislature, where you cannot intervene between the works, and also we have kept judiciary at the level much superior, little bit superior to the executive and legislature, because judiciary is like the watchdog and watchdog of the entire constitutional provisions of the country, and judiciary is that particular body of the country which takes care and ensures that anything and everything, even the executive and the legislature, they are functioning or conducting their business in accordance to the law prescribed by the constitution through the acts that they are passing, whatever. But judiciary is at that particular role where it dominates, or it kind of oversees everything, whether or not if it is happening based on the constitutional provisions, with the very important tool they have, which is the judicial review, which is also part of the basic structure, right? So now the problem with this particular act is that the petitioners in Supreme Court argue that Parliament may have overstepped its authority by legislating over a constitutional bench judgment, right? In the Anoop Baranwal case, it clearly stated that CJI should be a part of the select committee, but the parliament did not listen, right? So the parliament right now might have overstepped. This is what one of the another biggest drawback, and this raises obviously the concerns about the legislative override of judicial directions, right? So this is also another important factor to consider with respect to the 2023 Act. Another important key challenge of the issue is with respect to the vacancies and the loopholes in the selection, the whole selection process, the selection committee. So the Act permits the selection committee to operate even with vacancies, right? Selection committee does have a particular number of members to be a part of it, be it the Prime Minister or the or leader of opposition, or even for that matter with respect to how the present Chief Election Commissioner was elected, the third person being the one of the cabinet ministers appointed by the Prime Minister, right? So the biggest loophole this Act talks about, that this selection of the Chief Election Commissioner by the PM, the leader of opposition, and the cabinet minister, right? This can happen even in the absence of the proper quorum in the selection committee. Let's say even if the Prime Minister is not present, still the remaining two can also basically select the Chief Election Commissioner. And also in case of the absence of the leader of opposition, even then both the Prime Minister and the cabinet minister can select the Chief Election Commissioner, is what the Act talks about, right? So if the leader of opposition post is vacant during the Lok Sabha dissolution, the Prime Minister and the Union Minister alone decide the appointments, which clearly undermines both the spirit of the judgment and the Act itself, right? So this is pretty evident, right? So this is another biggest drawback of this particular Act. So this pretty much seems like the government, especially the majority parties, has tried its best to give or make sure that the entire process of Chief Election Commissioner is more favorable to the majority party, right? Speaking of all the acts and the provisions that it includes. Now talking about another major issue is the threat to free and fair elections. So obviously when you see how the process of the entire election commissioner appointment is going on, right? The presence of two ministers, two cabinet ministers, two MPs, in fact the Prime Minister and the Union Minister from the majority party, and just by completely ignoring the Supreme Court's verdict of having the CJI, and also even in place of a vacant seat, let's say even if the leader of opposition is not there, even then Chief Election Commissioner can be appointed. Now is very eerie and very kind of problematic when it comes to thinking as to how free and fair the elections would conduct if this is the case, how the Chief Election Commissioner is appointed, right? So with 2 out of 3 votes under the executive control, talking about the selection committee, the independence of the election commission becomes questionable, obviously, right? Because 2 members from the selection committee are from the majority party, let's say the Prime Minister and the Union Cabinet Minister himself, right? So now obviously if a person is put in front of the selection committee, now if he is from the party favored group of candidates, obviously the quota would be to vote from the Prime Minister and the Cabinet Minister, and 1 will be from the leader of opposition, which clearly states that the one whom they have preferred, the person who is preferred by the majority party, just in case if that is the situation, will obviously become the Chief Election Commissioner. So this kind of does not ensure that how free and fair elections would happen further after when this person becomes the Chief Election Commissioner, right? This concentration of power may create bias in favor of the ruling party is another important issue. Next is the credibility at stake, right? What is credibility? The search committee for shortlisting candidates, the search committee, the panel of members who search the members, the candidates for to become the Chief Election Commissioner, is executive dominated, raising doubts about neutrality even before the appointments are made, right? Even before the appointments are made, this search committee is filled with those people or is executive dominated, meaning which the search committee is also part of is filled with those ministers of the union cabinet ministers from the majority party itself, right? And also it is purely executive dominated, right? So which obviously raises the doubts and about how neutral the election or the entire process is in terms of selecting the number of persons or the kind of persons to be the chief election commissioner. So perceived bias in election commission selection could erode the public trust. This would obviously ensure that it will definitely erode the public trust in the entire election process, which is actually the foundation of any democracy, right? So that is all with respect to the issues with respect to the present act. Now talking about the way forward, first and foremost thing is to have an independent collegium system where we can establish a transparent and a bipartisan body which includes the prime minister, leader of opposition, and the CJI. This is pretty much to implement the Supreme Court verdict, or to make sure that any eminent civil society members, to ensure balanced selection, right? So we have to try and ensure that the cabinet minister, which is the third member, to be removed and follow the Supreme Court's verdict. And this is one of the way that it can strengthen the autonomy of the election commission, right? Or strengthen the autonomy of the people who are present in the select committee to select the most desired candidate, right? And second important thing is to strengthen the autonomy of the election commission, right, by providing financial independence, by making sure that the expenditure of the election commission is charged on the consolidated fund of India, to make sure that it insulates it from the government pressure. And last one is the legal clarity, right? In place of the Supreme Court verdict and all of that, it is pretty advisable a constitutional amendment has to be passed. Of course, it is practically not possible considering the present majority that the opposition has. But this is one of the way forward, considering a constitutional amendment which can clearly define the appointment process, preventing ambiguity and recurring the litigation, right? So these are the few way forward. Now coming to the end of the video, it is important to keep in mind that this particular issue is very important to ensure that the credibility of Indian democracy rests heavily on the neutrality and the independence of the election commission, right? Because one of the key determinants of any working proper democracy is free and fair elections. So if that is not happening with true spirit with which it is supposed to happen, any democracy is shattered into pieces, right? So credibility of Indian democracy can be ensured only with the presence of a neutral and an independent election commission, and any perception of executive control will definitely undermine or take the entire dynamics of the chief election commissioner down. The entire body will put down just because the executive control is seen in the election process and in the appointment process of the chief election commission, and it will also erode the public trust in ensuring that the chief election commission or the election commission would ensure free and fair elections going forward. So in order to protect the sanctity of the electoral process, reforms must ensure that the appointment of chief election commissioner, as we have discussed in terms of the addressing the key issues, that the appointment of the chief election commissioners and the election commissions should be made transparent, bipartisan, and insulated from the political interference. I hope it is very clear with respect to what chief election commissioner is, what chief election commission is, right? So that is all for today's video. I hope you have understood everything about what we have discussed today. If you have liked the video, please hit the like button, and don't forget to subscribe Believers IAS YouTube channel for more such informative content. Signing off, this is Madan Gopal. Have a beautiful day.